All right, we'll call our second case today, which is Bayview Loan versus Jason Cross. And I would also advise counsel that after we finish the second case, if they want to join us for coffee in the lawyer's lounge, we'll be happy to meet with you. Give me just a minute, counsel.
Yeah, sure.
All right, counsel, you may proceed.
Thank you, Your Honor. May it please the court, my name is William Eisenberg. I'm with the law firm of Phelan, Hallinan, Diamond, and Jones, PLLC. And I'm representing Bayview Loan Servicing, LLC, before this court, seeking a reversal in most part from a final judgment rendered in the trial court below. We're asking the court to reverse the conclusion in the final judgment holding that the defendant Oppley Cross was entitled to prevailing party attorney's fees under Florida Statute 57.1057. Such a reversal would be dispositive of all the other issues in the case.
Well, you understand that we're bound by our own cases and that we've decided, if I understand the way this case worked out, the judge ruled against you originally because they concluded that although you had standing at the time of trial, there was no standing at the outset.
That is what the court concluded, Your Honor.
And that was affirmed on appeal.
That was affirmed on appeal.
And how do you, most recently, I think in our case called Madel versus somebody, Madel.
Madel, yes, Your Honor.
We said that if you have no standing at the outset, but you have standing by the time of trial, then there can be an award of attorney's fees. Now, I understand the Fourth District has put down a very hard line that is different than that, but why aren't we bound by our own case?
I'm asking the court to the Fifth District to recede from its opinion in Madel.
You agree that Madel is against you. You think that Madel's wrong and we ought to go with the Fourth and recede from that?
Well, to an extent, Your Honor, I believe that you should go with the Fourth, but I think that you should also go with what really makes common sense when you look at the nature of standing in the context of a mortgage foreclosure case.
Well, but let me just come back and understand from a procedural standpoint. Is there any way that we can rule for you without receding from Madel or Madel?
No, Your Honor.
Okay, so your argument here is we're bound by Madel, but Madel is wrong, the Fourth got it right, and we should recede from that.
Yes, Your Honor. I think there's more to it than that, but certainly there is that.
Okay.
Didn't your brief argue that Madel didn't apply to the facts of this case? Based on some discussion of privity versus standing?
Your Honor, I think that in both cases, you had a finding that there was no so-called standing at the initiation of the case, but that you did have standing at the trial of the case. So I can't represent that Madel differed from this case as to those facts. I can't do that.
Sure does.
And Madel, or Madel, however you pronounce it, the mortgage was assigned to Wells Fargo prior to the lawsuit being initiated. The note, however, was not transferred. And so I think one of the issues in Madel in terms of standing was that, you know, the mortgage follows the note, and they did not have standing because although the mortgage had been assigned, the note had not been assigned properly as well. Is that similar to the facts here, Or is this different because the argument for standing was that neither the mortgage or note was assigned prior to the inception of the lawsuit?
I believe, Your Honor, that that's correct for Madeline. In this case, was a claim by Cross that there was an assignment of the note and mortgage. And in Cross's supplemental record that was filed with this court, there was a copy of the subject mortgage which did not assign the note and mortgage. What we did have, if there was quote-unquote standing at all in this case, it would have been based upon a note that was endorsed in blank. The note endorsed in blank was not present at the outset of initiation of the case. That's why there was no standing at the initiation of the case. After the case was initiated, after the complaint was filed, there came into the possession of the plaintiff the note, original note endorsed in blank. But that would be the only grounds for standing in this subject case, Cross, would be the possession of a note endorsed in blank. It would not be because...
Well, that makes you a holder. If you got a blank note, a note endorsed in blank, you're a holder.
I agree, Your Honor.
So, I mean, isn't it very clear that at the time of the trial, when you hand the judge the note endorsed in blank, that demonstrated that you had standing at that point?
No, Your Honor. See, that's the rabbit hole that we fall into. Because if we, Bayview, had standing at the time of trial, Bayview would have had some rights. Bayview had no rights whatsoever.
Well, maybe I've got my facts wrong, but I understood that the note that was attached to the original complaint did not have an endorsement.
That's correct.
By the time of trial, you show up with the original note with a blank endorsement.
That's also correct.
And that makes you a holder, right?
Yes, Your Honor.
So you've got the rights of a holder.
Your Honor, the problem is that...
Well, wait a minute.
Okay.
I mean, if you're a holder, you have the rights of a holder.
You're supposed to, yes.
Right. Now, the problem that you run into is that the case law, and I'm not sure that I necessarily agree or not, but the case law says it's not good enough just to have standing to be a holder at the time of trial. You've got to have standing when you start the fight, at the initiation of the lawsuit. That's the problem that you had here.
I agree.
So why doesn't Madel, well, I mean, I think you already conceded that unless we recede from it, Madel controls, because you were a holder at the time of trial.
We were a holder at the time of trial. The problem is that in the context of a mortgage foreclosure case, if you're a holder at the time of trial, but you're not a holder or don't have standing at the initiation of trial, you're being a holder trial, it means nothing. It gives you no rights. It's counterintuitive. I had a...
No. It gives you the rights of a holder. The problem is you weren't a holder, or at least you didn't prove that you were a holder at the initiation of the lawsuit.
Yes, Your
Which is a
Honor,
procedural matter, not necessarily a substantive one.
Well, I believe it is a substantive one, and I also believe that the trial judge, also I'd like a 5-minute reserve if I may. The trial judge in the Cross case believed it was substantive as well, because the trial judge bifurcated the case to the extent that the trial judge said, Mr. Defendant, you win, but you don't have any rights to seek attorney's fees at any point before the trial, which we know is incorrect. But that's why I refer to this set of facts as...
Tell me that again. You don't have... The trial judge said that they could not seek fees prior to trial.
Yes, Your Honor.
And you're saying that was incorrect?
It is incorrect. They could not seek fees. Cross could not seek fees at all.
Okay. So you're saying that you don't agree that they were entitled to fees at all. You're not arguing with where the judge drew the line.
No, Your Honor. I understand why the judge drew the line there, because
Okay.
as I said, if there's a theme to the situation, it is going down the rabbit hole. Because you are in a situation that's really almost impossible to deal with logically. And if I may, I'll give you an example why. Consider a drop of water, H2O. If I don't have a molecule, if I have one atom of oxygen over here, and I don't have two molecules or two atoms of hydrogen.
I should tell you, the reason I'm a lawyer is because I failed freshman chemistry.
It doesn't
So
look
you-
like I'm doing a great job either, Your Honor.
Well, I think you failed freshman chemistry, too. I know I did.
Can I clarify some facts?
Absolutely.
Okay, so my understanding is that at the time the lawsuit was filed, there was a mortgage attached that had SunTrust's name on it.
Yes.
And an unendorsed note.
Correct.
So at the time that Chase files the lawsuit, Chase is not a party to any contract. They have no rights to enforce anything.
Correct. No
In
standing.
contrast from Madel, where there was at least a mortgage assigned that had a prevailing party's attorney's fee provision in it prior to trial.
In Madel, I believe that the standing was not until trial, but not at the initiation.
Right, because they didn't hold the note, and then the mortgage has to follow the note.
Yes, Your
So then Chase, then in 2011, Chase files the original note endorsed in blank.
Correct.
So at this time, presumably, Chase has full rights of enforcement, right?
Chase would have, I call it so-called standing, because it's standing that's illusory. It doesn't give Chase any rights.
So would you agree then that Chase had standing at the time of trial? Or I think at that point it was Bayview.
It did have standing because it was a hold of a note, but it didn't have standing to enforce because it didn't have standing at the beginning of the trial. They're contradictory statements. I understand that, but that's what we're left with.
So for purposes of attorney's fees, you don't think that they should have had you don't think that the trial judge should have awarded fees at all, correct? I just want to make sure I understand that.
That is correct. Under 57.1057, I do not believe that the defendant should have been awarded attorney's fees.
But you agree to come to that conclusion, we have to ignore or recede from Madel.
I absolutely do agree with Your Honor.
Okay. And you recognize that's a completely different position than is asserted in your briefs. I mean, it is fundamentally different.
I'm not going to disagree with Your Honor. I prepare for oral argument. I can't disagree with Your Honor.
Okay.
Okay, so let's assume that Madel applies. Do you agree then with the trial judge's decision on the bifurcation aspect?
No, Your Honor. I don't agree with the trial judge that the defendant would have the rights to attorney's fees from the time of the trial forward.
Well, I understand you don't think they get fees at all, but if we do not recede from Madel, it seems to me that there's two choices. They either get fees for everything, or they get fees from the time that you all acquired standing forward, which I guess the only evidence is by the time of trial you had standing. So it seems to me that the three choices we have are recede from Madel, in which case they get no fees, give them fees for everything because you had standing at the time of trial, or do what the trial judge did, which says, the best I can tell is by the time of trial you had standing, so give them fees from that point forward.
That's accurate. Those are the three choices the court would have.
So everything is premised, then, in your argument, is premised on Madel. What's your position if we choose not to recede from Madel? You agree that if we don't recede from Madel, then they're entitled to fees of some amount. So the question is, where do we draw the line?
That's correct, Your Honor. And in Madel, they didn't, this court didn't bifurcate.
Right, we weren't required, or we didn't anyway, say where the line gets drawn.
Yes, Your Honor.
In this case, apparently the judge drew the line, and I understand the logic of it. Why do you think the judge got it right, assuming that Madel is what we're stuck with?
Obviously, if I'm going to lose on,
You'd
as
rather
far
lose
as Madel
small
goes,
instead of big. Right, I get
it would be selfish of me, but I would have to ask that the fees go forward, but I would be disagreeing with my own logic, so I'm kind of in a tough position.
I get it. You're down to your 5 minutes.
Yes, Your Honor. I just want to make one quick point and then reserve, and that is I think that it's important for this court to consider its own opinion in Deutsche Bank National Trust Company versus Alacqua, which is 197 3rd 662, and the quote from that case is, Deutsche Bank attached a copy of the note and mortgage to its complaint. 3 endorsements, the last one specifically to Deutsche Bank. Sometime thereafter, the bank filed the original note with the clerk of a circuit court. The note had the same endorsements as the note attached to the complaint. And this is what I think is critical. It was at this point, you stated, the bank had established standing to sue and its entitlement to enforce the note. So you have so-called standing at the initiation of the case, but you have no rights to enforce the note at the initiation of the case. It's only when you had standing at the initiation of the case and then at trial that you had standing that you put together these two indivisible halves and you make a whole, which is standing to enforce. That's why the word standing is so confusing. Standing at the initiation in the context of foreclosure doesn't mean anything. Standing at time of trial by itself doesn't mean anything. You have to have those two.
Don't you agree that to file a foreclosure suit, all you have to allege is that you hold the note? You don't have to attach any assignment or anything else to the complaint. You allege, we hold the note, therefore we're entitled to enforce. Isn't that what gives you the right to sue?
That gives you the right to sue, but not to enforce. I mean, standing means you have the right to walk in the door.
Haven't our cases said that exactly? That it gives you the right to enforce the note?
No, Your Honor. You have the right in a complaint, if you state a cause of action, to walk in the door. The defendant, if he states a good defense, has the right to walk in the door.
673-3011, person entitled to enforce the holder of the instrument.
Mm-hmm.
Period.
I'm sorry?
Doesn't section 673.3011 say that the holder of the note is entitled to enforce, period?
Well, yes, Your Honor, but...
And didn't we say that in Deutsche Bank versus Lippy?
Yes, but you have the right to enforce under the statute. But if you go to court and you have the right to enforce because you hold, but somehow at the time, at the initiation, you have the right to enforce. I'm sorry, you have the right to, as a holder, but at the time of trial, you don't have the right as a holder, then you can't enforce. Or if you have the right to enforce at the beginning and you don't, if you don't have the right at the beginning, but you do have the right at the end, you can't enforce. So that's why it's so complicated. You have standing, but unless you have it at both ends, at initiation and trial, you don't have standing, and you lose. And that's Madel. You lose, Mr. Plaintiff. Thank you.
All right, thank you, counsel. You got a minute and a half, but I'll give you an extra minute, and the same for
Thank you.
same for the other side. How much time would you like for your reply?
5 minutes should be sufficient. Thank you.
Okay, let me just adjust the clock here. You know, if you'll just agree with him, we can all go home.
Yeah, absolutely.
Good morning.
Good morning. May it please the court. My name is Ryan Gantos with Gantos and Branch, and we're here on behalf of the appellee, cross-appellant, Mr. Cross. We are here asking that the court not recede from Madel, as the court, I suspect, new.
Do we really have to recede, though? Because isn't this case distinguishable, similar to the question that I asked before? In Madel, the mortgage was assigned prior to the inception of the lawsuit. And that is what the court relied on for the attorney's fees provisions to enforce fees from the beginning of the lawsuit going forward, regardless of the standing issue. And here, there is no such attorney fee provision that exists to which the parties are in privity with prior to the inception of the lawsuit.
We would respectfully disagree that Madel does not control. In Madel, the inquiry that reached the appellate court at the first final judgment was whether Wells Fargo as trustee had standing at the commencement of the suit. The analysis focused on the note that was attached to the initial complaint, which did not bear an endorsement in blank. There was thereafter a discussion about how Deutsche Bank, another party who had commenced a corresponding foreclosure on another case on the same note mortgage, then delivered to Wells Fargo as trustee the original note.
That's kind of the fourth position: no standing, no privity, no fees, right? But the fifth has taken a more nuanced approach. But doesn't, even in the fifth DCA, there has to be a requirement that there is some contract to which the parties are privy to providing for fees prior to the inception of the lawsuit.
The Madel opinion in Floyd also required that the parties be parties to the contract. It does not say prior to the suit's commencement they need to be a party to the contract.
But in fact, that was the facts in Madel, that there was a contract prior to the commencement of the lawsuit.
We believe that Madel suggested that though there was no standing at the inception, which was their finding, which is why they reversed final judgment, they determined that at trial, the note that was endorsed in blank and transferred to Wells Fargo as trustee by trial rendered them a party to the note and mortgage.
So wouldn't we be extending Madel by applying it in this case?
We don't believe so, and we don't believe that Madel would have been reversed at all if there was evidence that the initiating party had been a party to the contract prior to the suit's commencement in conjunction with Wells Fargo's possession of the note endorsed in blank at trial. We don't believe that there would have been a reversal at all. The court emphasized the negotiation of the note endorsed in blank, and once it was established that there was a post-dated endorsement in blank on the original note admitted into evidence at trial, judgment was rendered for the defense because there was no evidence that the endorsement was on the note prior to the suit's commencement, and that's why it was reversed, which is precisely what we have in this case. And Floyd also found that the defense and the borrower were entitled to attorney's fees and costs despite having prevailed on a standing at the inception defense.
There's not a lot of explanation of the facts in Floyd, right?
There is not.
Right, so not
they
a lot
did
of
not.
application in this case. So let's assume that this would be an extension of Madel, because at least in Madel there was some sort of contract to which the parties were privy to when the complaint was filed. Why would we adopt a rule that if at the time the lawsuit is filed, the parties aren't parties to any contract, there's no enforceable contract, there's no right for Chase to collect attorney's fees because they're not a party to a contract with attorney's fees, how under a reciprocal fee provision could a defendant then rely on a non-existent contract?
Well, in this case, there was an assignment of mortgage between Chase and the original lender by way of an assignment of mortgage. It just happened to be dated the same time that the lawsuit was filed. It was also executed on November 16, 2009.
Didn't the court also find that an issue with the assignment because there was a gap in the assignment, so the court found that assignment was invalid and therefore they were not, they argued two bases. They argued holder and then they argued non-holder with the rights of the holder, and the court also went through that analysis and found that the assignment was invalid.
I don't believe the court found that the assignment was invalid. I believe that they determined that Chase was not in possession of the note when the suit was commenced, and the assignment of mortgage did not predate the suit's commencement, and that was what was briefed fairly extensively on the first appeal, which the court affirmed on that position. I do know that there was reference under the trial court's analysis as to the shelter rule, but that was because at trial we had converted from a holder case into a non-holder case.
What about page 355 of the record? The court talks about the fatal flaw in the change of transfers didn't establish that MERS had possession of the note and transferred possession to Chase. Then it talks about how JP Morgan had received possession, and then there was no indication that it lost it, so that MERS wouldn't have it. Isn't that an indication of a problem with the chain of assignment? And that's why Bayview didn't have, wasn't a non-holder in possession.
Well, first, I believe that was the third basis for the court's dismissal. The court first concluded that there was no dated documentation establishing Chase's relationship to the note mortgage prior to the suit's commencement, and that another party, JP Morgan, was actually in possession of the note. Those were the first two bases. And then, yes, the court did mention that there was an absence of evidence concerning the prior non-holder in possession's right to transfer. But that doesn't change the analysis in this case, because at trial, it was established and it was conceded by us, and the trial court acknowledged that Bayview was the holder of the note and mortgage. They were a party to the note and the mortgage. That's not even in dispute. They've conceded that on the briefs. So because at trial, they were the party to the note and mortgage, they are obligated under the note and mortgage's fee provisions to pay attorney's fees. So we don't...
Even though that contract did not exist at the time the lawsuit was filed.
And again, I believe that would be the Madel case, and we believe that the Madel case expressly turned on whether there was an absence of standing at the inception, which there was. So the court reversed final judgment. That's what we have in this case. The court, I believe, and this is me piecing together what perhaps the parties were trying to do in that case, they may have been arguing that the assignment of mortgage, because we're dealing with the transfer of a note, is not the effective way to transfer the note, because the way you're supposed to do it is an endorsement and transfer. And they may have said that the assignment of mortgage didn't do that, and they may have been following the Jellick case out of the 4th DCA, and then they may have then switched over to emphasis on the note's endorsement, but that still wouldn't change the analysis, because we still have a contract between Bayview and we still have a contract between my client. And my client stipulated to the execution of that document, of the note and the mortgage. My client, or excuse me, we had conceded Bayview's standing as holder at trial. Bayview advanced that point. They successfully maintained that position as well, because they had to prove, as this court has referenced, they had to prove standing at inception and standing at trial. One of the elements of their foreclosure case was to prove standing at trial, and they did that. So they successfully maintained that position, and they're bound by the note and the mortgage. And we would respectfully request that the court excuse me, find that as well.
Let me jump ahead a little bit, and let's talk about where the trial judge drew the line as far as the award of fees go. So let's assume this hypothetical. Plaintiff has no standing at the time of the initiation of the lawsuit, but just as the trial's about to begin, as they're walking through the door at the courthouse, somebody hands them the note endorsed in blank, and they obtain standing because by that point they've got the blank endorsed note and they own it. Now, it seems to me that what the trial judge did here was say, well, that's at least, we know you had standing at least at the time of trial, so we're going to award fees from that point forward. Why is that illogical? Why should you get fees back to the beginning of the lawsuit or some place in between when your argument was the bank was a stranger to the contract and had no rights? If they didn't have any rights, why would you have rights to collect a fee?
First, we didn't contend that any party was a stranger, and the court didn't make any findings to that effect. But we do disagree with the court's decision to bifurcate our fee entitlement claim, because we look to the note and the mortgage. We look to Florida's UCC. The note and the mortgage does permit partial transfers of the note and mortgage. There was no partial transfer in this case. The note and the mortgage were assigned in its entirety to Bayview as holder through Florida's UCC through transfer of the endorsed note in blank. So there was no mechanism that would have spliced out the attorney's fees.
You don't have any way of knowing when that endorsement was put on there and when they came into possession of it. There was no proof of that. All we can tell is that they didn't have it at the outset. They did have it at the time of trial.
That is correct. And
So, I mean, it seems to me that the judge adopted a fairly pragmatic view and then said, well, we know they had standing at the time of trial, so I'll give fees from that point forward. But there's no evidence that they were in possession or a holder or had the rights of a holder or anything else at the time of the initiation of the lawsuit. I mean, that was the real problem. And so why is it logical then to go back to day one when the lawsuit is filed to award fees?
a couple answers. First, the right to recover attorney's fees is my client's, and he retained counsel in 2009 and was represented throughout. So his right under the reciprocal fee provision of Florida Statute 57105 subsection 7 tells us it's his fee claim.
But it's only reciprocal against whom?
It's reciprocal against the plaintiff, in this case,
No,
Bayview.
it's reciprocal against the party to the contract.
Correct, that's Bayview.
And, well, your argument was they weren't a party to the contract at the initiation of the lawsuit.
Our position was that the timing was off, that Chase Home Finance failed to present dated documentation establishing its relationship to the note and mortgage prior to the suit's commencement.
So there was no proof that they were Chase or Chase was a party to the contract when the lawsuit was filed. So I guess my question is, how can you have a reciprocal fee agreement against somebody who hasn't demonstrated, or you haven't demonstrated, that they were a party to the contract?
Well, Chase did become a party to the contract. They filed the original note endorsed in blank on August 9, 2011. They also had the post-dated assignment of mortgage, which transferred the note and the mortgage to them. It just wasn't prior to the suit's commencement. So it's undisputed that Chase became a party to the contract. So we are allowed to invoke our reciprocal rights against Chase and its successors.
And that's the thing, Chase wasn't a successor, because, so in 2009, when the lawsuit was filed, somebody was a party to the contract. It wasn't Chase, though. And so the plaintiff would only have the rights of the person who was actually a party to the contract, but that existed outside the lawsuit at the time that the lawsuit was filed. Right?
But it's correct that they did not have standing when the suit was filed. But the assignment of mortgage did transfer the note and mortgage to Chase, and they did file the original note endorsed in blank. So Chase became a party to the contract. The record tells us that. The filings tell us that. And then as far as Bayview's interest, it's undisputed they entered the note and the mortgage without objection, bearing an endorsement in blank. And the note and the mortgage, and this gets back to why is it logical? Well, we believe that it's what the law would require. Florida's UCC permits transfers. This note was transferred several times through the course of this lawsuit. It would be unfair to limit our right to recovery just to the latest person in line. It's a fee provision that's stuck in the note and mortgage that was filed with this court when the suit commenced in 2009. And the note and mortgage do not restrict liability as to attorney's fees subsequent to their acquisition of the note and mortgage. 57105 subsection 7 does not do that as well. It says party to the action. If you're required to take action to enforce, the other party is entitled to their attorney's fees if they prevail. So the note and mortgage do not splice out attorney's fees and costs. The 57105 does not, and Florida's UCC does not either. The endorsement in this case does not say we're transferring some of the note or some of the provisions but not the attorney's fees, or the attorney's fees will take effect once it's transferred. It's one note, it's one mortgage, it transferred hands numerous times. Bayview was the party that presented it to the court. They were the holder of the court at trial, and they are obligated to pay the attorney's fees provision in full. So we would ask that the court follow, we do note that this matter has not been directly ruled on. We do note that. Counsel, in their brief, they also acknowledge that there's not a case directly on point, but we would suggest that Maddle, Floyd, and Harris would support a entitlement to the entirety of your attorney's fees, a motion to tax fees granted in its entirety, and then allow us to present our evidence on the fees incurred prior to trial.
You would concede that Mattel doesn't really address the point of where do we draw the line. We
That's
said give them
correct.
fees.
That is absolutely correct.
And it wasn't an issue in that.
That is absolutely correct.
So
I'm just saying
to-
as a
to-
general matter, it was reversed, and it was not remanded back to determine when attorney's fees should start being incurred and
When was
whether
the-
fees should be incurred.
When was the note filed with the court that had the blank endorsement?
That would be August 9th, 2011.
Did you ever argue at the lower court or in your brief that if there was an error with the bifurcation, that the error was that it should have, the fee should have commenced in 2011 rather than at the beginning?
We were confronted with that issue at the fee hearing. The trial court in this particular case on the entitlement inquiry is very studied. He's very educated. He presented that novel bifurcation argument to me at the fee hearing, or excuse me, at the entitlement hearing. And when presented with that, the transcript probably would reveal that it wasn't the most eloquent response as far as my position, but I tried to dispute what the court was doing at that time. So we were unaware that that would be a position advance prior to our entitlement hearing. Our entitlement hearing happened in 2016. Trial happened in 2015. Many of these issues with Glass and Fitzgerald were not even adjudicated yet.
Was
So
there any rehearing filed asking the court to start attorney's fees in 2011?
there was a request for reconsideration, but it was not ruled on. So there was not a final determination on the request for reconsideration.
Was it argued, though? I'm just
It was,
asking.
it was not argued. Part of the reason why it wasn't argued, it was not argued, the simple answer. But part of the reason it wasn't argued is because we had to litigate rather extensively the underlying entitlement inquiry, much like we're doing here today. And when we were at court, that's simply what the court ruled on. He had ruled on the plaintiff's request for reconsideration, and we didn't even reach my separately filed response.
Counsel, you're down to 2.5 minutes, but as I told your opposing counsel, I'm going to give him an extra minute. I'll do the same for you.
Okay, thank you.
Sometimes after arguing a matter for quite a bit and making a lot of different arguments, everything comes back to where it started, which is, in this case, 57-1057. As you know, the provision states, if a contract contains a provision allowing attorney's fees to a party, when he or she is required to take any action to enforce the contract, the court may also allow reasonable attorney's fees for that other party when that party prevails in any action, whether it's plaintiff or a defendant with respect to the contract. As you also know, it's a statute that's in derogation of a common law and thus must be strictly construed, and that the letter and the spirit of 57-1057 is that we want to make things fair. We want to make them reciprocal. And I would ask the court to consider that to have the plaintiff have no rights under any contract in this particular case to prevail and to be able to enforce any of the provisions of that contract, but to have the opposing party, the defendant, receive the rights to enforce the contract, in particular the rights to seek attorney's fees under 57-1057 is hardly reciprocal. And that is the basis of the argument that I presented to Your Honors during the first.
Doesn't the basis of your argument mean that if Bayview would have won in the trial court, they wouldn't have been entitled to the fees under the note and mortgage?
If Bayview had prevailed because it had unified standing, standing at initiation.
I'm taking your facts the way they are. Let's say that the judge made a determination for Bayview, doesn't, when you play the logic out of the argument you've made to us, that because there was no contract at the beginning, they would have been precluded from seeking the fees under the note and mortgage.
But if you take the opposite view, if Bayview had prevailed at the time of trial because it did have standing, then Bayview should have prevailed and should have been entitled to attorney's fees and to foreclose because it prevailed at trial. But even though it was a party to a contract at the time of trial, and that contract allowed for the mortgagee to foreclose and the mortgagee get to attorney's fees, even though Bayview had those rights or should have had those rights at a time of trial, it didn't. And that's because you have to, as I said, you have a unification of standing at initiation, standing at trial. You have, as I said, you have neither. So, in fact, Bayview, it may be a party to a contract in a sense, but it's not a party to a contract in another sense because it has zero rights. And again, that's why I say, where's the
Counsel, you've
reciprocity?
exhausted-
It doesn't
You've
exist.
exhausted your time. Thank you.
Thank you.
I wanted to comment real quick on the Madel distinction. I'm trying to recheck the opinion as quickly as I can. There was reference to an assignment of the note and mortgage, but it didn't state in the opinion itself that the assignment of mortgage predated the suit's commencement. That may have been a fact in the briefs or in the record, but it wasn't presented in the opinion. The operative ruling from Madel.
State in 2006, Impact assigned the mortgage to Wells Fargo. And the lawsuit would have been brought by Wells Fargo in April of 2009.
Okay. And my understanding of Madel is the operative ruling from that case states that standing and being a party to the contract aren't necessarily the same things. You can have an instance where you don't have standing, but you're a party to the contract, which is what we have here. Standing at inception is different than whether Bayview was the holder of the note and mortgage, which was an undisputed fact at the lower level. And that analysis was expanded upon, or at least adopted in Harris in the second DCA, and it tells us that the same thing, that we look to whether there's any transfer documents to the party you're seeking attorney's fees from. In Harris, there was a pre-suit assignment of mortgage, but a post-assignment of mortgage transfer to another party prior to the suit's
So
commencement.
again, like in Harris, like in Madel, there was a contract to which the parties were in privity to prior to the inception of the lawsuit mortgage.
There was a assignment of mortgage that in 2012 in Harris, but it was still determined by the Harris court that the initiating plaintiff lacked standing when the suit commenced. So I still don't believe that the operative inquiry is whether the transfer document existed prior to the suit's commencement. It's whether the transfer document exists at all.
So I think, so is your argument basically if you have standing at any point, you get fees throughout the
Yes.
lawsuit? Okay. That makes sense.
And if the court doesn't have any further questions, we'll rest on the briefs, and we would ask that the court affirm the positions that we've advanced in opposition to our opponent's position on appeal, and ask that the court act in accordance with and rule in accordance with our issues on cross appeal. Thank you.
All right, counsel, thank you all so much. We'll finish for the day.